Hi, I'm Tim Sandifer, a principal attorney here at the Pacific Legal Foundation. In a few days, we expect the Supreme Court to issue its decisions in the constitutional challenge to the Obama administration's health care law. And here's what to look for when the decisions come out. There's a few issues that the justices will have to decide first. The first one is a jurisdictional question, whether the Supreme Court can even hear the case in the first place. Under an old law called the Anti-Injunction Act, courts aren't allowed to review the constitutionality of certain laws if they qualify as taxes, and the federal government has argued that this law falls under that protection. I think it unlikely, having heard the oral argument, that the Supreme Court will decide that it can't hear this case. The next issue is the constitutionality of the individual mandate. That's the provision of the law that forces you to buy health insurance whether you want to or not. That, of course, is the issue that has brought on so much attention to this case. And I'm feeling pretty confident after the oral argument that the Supreme Court will find that this law goes a little bit too far, even under existing precedent, by allowing the federal government basically unlimited power to do whatever it thinks is a good idea. The next issue is severability, whether the Supreme Court has to strike down the entire law at once or whether it can cut out just the individual mandate and leave the rest standing. The oral argument seemed to make clear that the justices believe that if any part of it should go, the entire law should go. After all, if they take out only one part and leave the rest standing, we'll be left with a law that nobody in Congress voted for. Nobody in Congress would have approved of this law if it hadn't included the individual mandate. So it would be even more undemocratic for the court to basically rewrite the law. The final issue that the justices have been asked to decide is the constitutionality of the expansion of Medicare. This is a provision of the law that requires states to expand eligibility for Medicare, whether they want to or not, and add people onto their Medicare rolls. And if they don't, the federal government will withhold all their Medicare funding, which in some states' cases is 40% of the entire state budget. The Supreme Court has said that Congress can pay states money in exchange for them doing certain things. But they've always said that if the federal government offers too much money or threatens to withhold too much money, that would be twisting the states' arms and depriving them of the right to make their own decisions as states. If anything goes too far, it's this law. However, it seems unlikely that the court will reach that issue, since if it strikes down the individual mandate and then strikes down the rest of the law also, it won't have to issue that decision. Nevertheless, it's possible that some justices might issue their own decisions and set precedent for future challenges to spending clause enactments. The federal government, after all, has expanded its powers tremendously by exploiting the spending clause power. And if the justices reach that issue, it could open the door to a re-examination of some of the most heinous, extreme expansions of federal power at the expense of the states. If you'd like to learn more about the Obamacare cases and about Pacific Legal Foundation's challenge to federal overreaching, you can check out our blog at blog.pacificlegal.org.